Welcome to SCOTUScast, a project of the Federalist Society for Law and Public Policy Studies. Our contributors join us from around the country to bring you expert commentary on U.S. Supreme Court cases as they are argued and decisions are issued. The Federalist Society takes no position on particular legal or public policy issues. All expressions of opinion are those of the speaker.
Hello and welcome to SCOTUScast. I'm your host, Justin Drower, on behalf of the Faculty Division of the Federalist Society. We're here today to discuss Department of Education v. Brown and Biden v. Nebraska, which were argued before the court on February 28th. It's my honor to introduce our guest today, Mark Chenoweth, who is President and General Counsel of the New Civil Liberties Alliance. So I'll hand things over to Mr. Chenoweth.
Well, thank you very much. I just wanted to say that I'm going to start with the Biden v. Nebraska argument. And this was a fairly high quality argument with many interesting angles explored. So we're not going to be able to cover everything. But I do encourage you to read the transcript if you didn't already listen to the oral argument. Solicitor General Preliger tries to lay out a simple case in defense of the administration's loan forgiveness program. She said that secretaries of education from the Trump and Biden administrations had already invoked the HEROES Act to suspend payment of principal and interest during the pandemic. So this is just a further extension of what she termed that unchallenged authority. She says student loan borrowers will be worse off without this relief because ending forbearance without it will cause defaults and delinquencies greater than what occurred pre-pandemic. And so Secretary Cardona crafted debt relief to ensure borrowers would not be worse off. So two quick things about that. First, the idea that this is unchallenged authority isn't true. Even in the context of this case, the New Civil Liberties Alliance in our amicus brief to the court actually challenged the forbearance authority and said that it was unlawful as well. So it's not true that that's unchallenged. And then the idea that she said that that they're essentially going to forgive this debt to avoid defaults, that seems a little like a funny concept to me. That's essentially saying, well, the cure to shoplifting is giving everything on the shelves away. It's a very odd sort of way to think about how to stop default. In any event, the second point that she makes is that the states lack standing to challenge the relief. There's an entity in the state of Missouri called MOHELA that is set up as a separate corporate entity in charge of the loan disbursement in Missouri. She said it's a separate legal person, and the state's claims about tax revenues or revenues coming from MOHELA are self-inflicted and indirect and don't give the state a standing in this case. Her third point is that the best reading of the plain text expressly authorizes the secretary under the HEROES Act to quote unquote waive or modify, quote, any Title IV provision in an emergency situation. And no one in this oral argument, at least, took issue with whether or not the emergency trigger had been pulled here. Justice Gorsuch did ask, what authorities did the president sort of invoke, and did he ever invoke the HEROES Act as part of that? Preliger's answer to that was, well, this works in the opposite direction, that once an emergency exists, then the HEROES Act says that you can invoke the HEROES Act. Don't know that that's going to surface again, but that might have been an Easter egg that Justice Gorsuch was dropping. I don't think so, but we'll find out. What Preliger said is that loan forgiveness is a usual form of debt relief, and so that the secretary was acting in the heartland of his statutory authority and consistent with the HEROES Act's purpose in forgiving the debt. And lastly, she said that applying the major questions doctrine to override the clear text here would put the judiciary in the position of overriding the will of Congress in order to deny student borrowers critical relief. Well, let's hold off on the issue of standing for just a minute. We could spend the whole hour talking about that. It came up a lot in both cases. But let's jump instead right into the court's skepticism of the government's argument on the merits of Preliger's other 3 points. So first, as I say, Solicitor General Preliger got less pushback than she should have on what I think is a misleading claim that secretaries of education of both parties have invoked the HEROES Act to suspend principal and interest payments. It fell to Solicitor General Campbell of Nebraska to point out that, in fact, Congress had authorized 6 months of suspended interest and principal payment in the CARES Act. And it's true that Secretary DeVos had, for a few days before the CARES Act was passed, talked about suspension. But before there was ever any even opportunity to challenge that, Congress stepped in and essentially made the decision for the Secretary but did put a 6-month cap on that. At the end of that 6-month period, Secretary DeVos did extend that once into December and then another time in December. And I believe it wasn't until December of 2020 that the HEROES Act was invoked. So the idea that the HEROES Act has been in play from the beginning isn't really true. It was the CARES Act that was initially responsible for the suspension of principal and interest payments, and that was a statute of Congress. This case thus bears a striking similarity to the Alabama Realtors case, which also dealt with something Congress did for several months. In that case, an eviction moratorium on federally subsidized housing that the administration then tried to extend for many months and expand beyond subsidized housing. And we saw what happened there when it reached the Supreme Court. The court eventually got fed up with that. And I strongly suspect it won't put up with Secretary of Education's extension and expansion of the CARES Act in this dimension either. But we'll find out. In any event, Preliger also claimed that no one, as I say, she said no one has challenged the use of the HEROES Act. And that may be true that no lawsuits have been filed on that, but the issue was joined in the amicus briefs here. And what Solicitor General Campbell pointed out is that the HEROES Act has never before been used to forgive a single loan. And Justice Thomas noted that loan cancellation or forgiveness is different than mere suspension of payment. And that brings us to arguments and Preliger's arguments about the text. Justice Thomas asked and pointed out that Congress uses express language regarding cancellation elsewhere, but not in the HEROES Act. And so he seems to be suggesting that a waiver or modification of provisions might not extend to a complete cancellation of debt. But Preliger says quite unabashedly that what the Secretary did was to waive any provisions that didn't apply and modify others by adding provisions that he wanted. So she calls it mapping the verbs. And of course, what she's talking about is wholesale rewriting of the statute. It would be like taking the sentence, Neil Armstrong was the first man to walk on the moon, waiving everything but the moon, and then modifying the sentence to add green cheese, and then producing the sentence, the moon is made of green cheese, and saying that that's merely a modified version of the original sentence about Neil Armstrong being the first man to walk on the moon. The resulting sentence is unrecognizable from the first. It seems to be far beyond a waiver or a modification. But Preliger is very insistent that the text of the statute is quite broad, that the Secretary can waive or modify any provision, so that the lack of mention of cancellation isn't meaningful to her, especially where no other forms of relief are mentioned either. So it's not as though 4 or 5 forms are mentioned and cancellation isn't mentioned. No forms of relief are mentioned. So she would have Congress handing the Secretary of Education the keys to the kingdom in terms of forms of relief that would be allowed. Chief Justice Roberts, interestingly, picks up on this problem and brings in Justice Scalia's notion from the MCI case that modification has to be modest, not a wholesale rewriting. And he notes we're talking about $500 billion here and something that impacts 43 million Americans. Preliger's short answer to that is that waive or modify is broader than just modify. And her limiting principle appears to be that the subject matter of loans is generally within the Secretary of Education's domain, so that he's apparently entitled to rewrite the law however he pleases, so long as there is an emergency and so long as he's still dealing with student loans. I don't know that the court's appetite for such statutory adventurism will be as robust. The chief notes that the law speaks of waiving provisions, not waiving loan balances. And when it came to be Solicitor General Campbell's turn to get up to speak, he made the point, which I think is interesting, that really they weren't even waiving these provisions because the provisions still apply. If you want to continue to operate under the provisions that existed before, you can still do that. So the provisions haven't been waived. Essentially what happened is certain provisions were added and other provisions were excluded, and a whole new program was set up, almost like sort of picking words out of a book and sort of just, I think red penciling was the term that Justice Amy Coney Barrett used to describe what the secretary did here. And it has a lot of a line item veto feel to it. And that's why the point Solicitor General Campbell made is, look, this has a Clinton v. New York problem. That was the line item veto case. If the secretary is allowed to do this, then the secretary is essentially line item vetoing parts of the HEROES Act, and that's not allowed. Even if Congress tried to give the secretary that power, we know from the line item veto case that doesn't matter, that it's still unconstitutional. So I don't know that much of a rewrite is something the court is going to accept, and I'm not sure what they would, how they would handle the Clinton v. New York precedent if they had to, if they decided that this rewrite was okay. Preliger boldly claims that Congress could not have been surprised one bit that a future Secretary of Education would take the HEROES Act and forgive $500 billion in debt. She says discharge is what it takes to make sure borrowers don't default. Again, it's the stop shoplifting by giving away the store sort of logic here. And look, that might work in an individual case like Jean Valjean and the silver candlesticks from Les Miserables. But the idea that Congress authorized wholesale canceling of debt to avoid default is a bit rich. And the point of avoiding default is to maximize repayment of debt to the government. Canceling debt does not maximize repayment when you're wiping it out in the process. Nothing is ever repaid then. So the government is guaranteed a complete loss versus at least a chance of repayment. And I just don't think the court is going to buy the logic that Solicitor General Preliger is selling there. The chief seemed to think, for one, that Congress could be easily surprised by the idea that borrower relief would lead to total loan forgiveness. Preliger tries to take the case of forgiving a single soldier's debt and uses that to say, and sort of spins out this hypothetical where a lot of bad things happen to a soldier on active duty, and the secretary decides to forgive that soldier's debt. And then says, well, if that's possible under the statute, then it's possible for 43 million people in this sort of wholesale way. Justice Sotomayor then picked up on the chief's mention of $500 billion and asked if this is a major question for these sort of economic impact reasons. And Preliger said it can't just be economic. And she offered some additional factors why she thinks that this case is not in major questions doctrine territory. Primarily, she said this is an administration of benefits, not a regulatory action that impinges on individual liberty. And several of the justices came back at her later in the argument on that point and tried to sort of suss out whether there was something. But the first swing came from Justice Alito, and he wanted to know if there's really a sort of doctrinal difference, or if there's really something that would justify treating benefits differently from regulatory actions here. And given that what we're really concerned about is the separation of powers, and that matters as much in the benefits context as it does in the regulatory action context. Preliger claimed that actually cuts in the government's favor, because when you think about separation of powers, the court is the one that would be overriding Congress's intent here. And I mean, kudos to her, I suppose, for sticking to her guns, but I think she's missing the thrust of Alito's argument. He pressed on whether Congress would need to be explicit before authorizing trillions of spending, and Preliger clings to the notion that the statute is clear, even though it's breathtaking in scope. And she also returns to her point about forbearance policy and no one complaining about forbearance policy. At that point, there's a long sidetrack on standing. We'll come back to that. And then Chief Justice Roberts is the one that brings the argument back to the major questions doctrine. So this is obviously how the lens through which he is looking at this case, having already mentioned it twice at this point. And he said that the separation of powers reminds him of the Dreamers case, where the Trump administration tried to unilaterally cancel that immigration program. And Preliger doubled down then on the idea that the court would be thwarting the plain language and the will of Congress. But the chief persisted and noted that a factor for the major questions doctrine is that if Congress would be expected to act on this. If this is something that has Congress's attention and it isn't acting, then that's meaningful. In other words, if Congress can't get something done and the bureaucracy then kind of comes in and tries to do it without going through bicameralism and presentment, then that's a problem. And what Preliger said is that there's legislative inaction on both sides of this question. So there were also legislative actions to try to reduce the scope of the HEROES Act, that those also failed, and that in the American Rescue Plan Act there was a provision that would not treat any sort of loan forgiveness as taxable. And so she said that was Congress essentially blessing programs like this. Justice Thomas then asked her about the appropriations clause, and Preliger said that it's not implicated here because no funds are drawn from the Treasury, and that alone puts it outside of appropriations clause analysis. Now, she did not explain how keeping money from coming into the Treasury is not just the flip side of sending money out from the Treasury, because if you're forgiving debt, you are keeping the money from coming into the Treasury that otherwise would be coming into the Treasury under the laws that Congress had passed. But Preliger once again invoked the forbearance, noted the $150 billion cost of forbearance, the ongoing $5 billion a month cost of the program, and said that if that's okay, then what the administration is doing with forgiving loans is okay too. Thomas offered that perhaps forbearance fits more comfortably into waive or modify language because the debt isn't going away, it's just being postponed. But Preliger said it's all of a piece because they're both costing the government money. So even though forgiveness costs $500 billion instead of $150 billion, that's not that far off. Justice Kagan then raised a few statutory arguments about whether the relief was necessary or whether it made borrowers better off. But she suggested that these aren't really statutory interpretation arguments about how to look at the HEROES Act, that rather these are questions having to do with whether or not the Secretary of Education made the right findings or justifications before acting here. In other words, she said these go more toward the question of whether the Secretary's line drawing was arbitrary and capricious. And Preliger readily agreed that these are arbitrary and capricious considerations. She says we're in a world where the statute tolerates overbreadth and allows class-wide relief. Just put a pin in that. Whether that's true or not, I think is debatable. But she said that in that world, the question is justification of the line drawing that took place. And all of the Secretary's noting of the financial impacts of the pandemic are enough to justify the lines he drew for arbitrary and capricious purposes. Now, interestingly, in the second case, in the Brown case, she comes back to this arbitrary and capricious point and essentially tells the court, look, if we're going to lose, we want to lose on these arbitrary and capricious grounds. And that makes sense because, of course, from their perspective, if they lose on arbitrary and capricious grounds, then in theory, at least, the Secretary of Education could come back, make additional findings, better findings, maybe tailor the program a little more, draw the lines at a different place, and then try to do the program again under the HEROES Act. Whereas if they lose under maybe more of a major questions doctrine approach that says that there isn't statutory authority to do this under HEROES Act, then they wouldn't be able to go again under the HEROES Act. They'd have to do it under other statutory authority if such statutory authority exists, or they'd have to go back to Congress. Perish the thought that they would get Congress involved here on doing something that costs $500 billion. But that would be where they would be. Justice Gorsuch at this point followed up with a question about the applicability of State Farm as to whether the Secretary adequately considered costs to third parties of the program, for example, the unfairness to people who pay their loans. And he suggested that if Congress were doing this, Congress would take a look at that. But Preliger admits that none of those considerations are in there, but she says that Congress already made the judgment about who would get student loan benefits when it passed the HEROES Act, and so that the Secretary doesn't need to gainsay that in doing his line drawing. Justice Kavanaugh jumps in at this point. He seems to agree with the Chief Justice and Justice Thomas that Congress could have said cancellation here, but didn't. And he asks that, aren't we just dealing with another old statute here with general language and a massive new program being created years after the fact. And so that this smacks of Brown and Williamson and UARG and the whole line of major questions doctrine cases. And he asked Prelogar why this doesn't fit that line. And Prelogar offered that the new program here is consistent with the purpose of the HEROES Act. She said Congress said all provisions could be waived or modified, and the secretary was acting within his subject matter lane. He's dealing with student loans, the core of his expertise. Kavanaugh said, but there are still winners and losers in the benefits context. And so he wondered why express authorization from Congress shouldn't be needed. And Prelogar claims it's hard to see what Congress could have done differently back in 2003. Kavanaugh ended with a sort of big picture question about the court's finest hours being when they've pushed back on executive assertions of emergency authority. I think he had the Steele seizures case in mind, for example, but he also mentioned some of the post 9/11 cases, which is interesting since he was in the White House during those years. But Prelogar said that there is less reason to be worried in the benefits context. And Justice Kagan also said that we worry about the separation of powers if the executive is acting without authority that Congress has given it. But as long as Congress has given the authority over, then we don't worry about executive power. Well, that's not the Constitution that I read. So I found that perplexing that Justice Kagan put that out there. I thought the point of separation of powers was that you can't have legislative power in the executive branch because those powers aren't supposed to mix. They're not supposed to be under the control of one branch of Congress. And when they are under control of one branch of Congress, bad things happen to liberty, as we have seen in this case. In any event, Justice Amy Coney Barrett then asked Prelogar about the red penciling done by the secretary. We talked about this a little bit earlier, and Prelogar said that the statute specifically directs the secretary to publish the terms and conditions that are going to apply in lieu of the waived and modified provisions. And so essentially he wasn't doing anything wrong by spelling these things out. A query whether there's a non-delegation problem here wasn't really talked about at all at the oral argument. The Clinton v. New York question did come up, so maybe that will feature in. Solicitor Campbell's argument to the court was quite direct when it came to be his turn. He said the Secretary of Education is bypassing Congress, which tried and failed to pass relief for student loan debt several times, that no statute authorizes the $500 billion write-off, that Missouri has standing, and that this is a major questions doctrine case given the amount at stake, and that this statute has never been used this way before, even to forgive one soldier's debt. So the statute allows waiving and modifying, not wholesale rewriting of the statute. The questions for the first chunk of the argument to Solicitor General Campbell focused heavily on standing questions. And Justice Thomas started things off saying, "Hey, you really ought to talk about Mohila here. You really ought to talk about the standing questions." And he was really faced a barrage of questions, I think it's fair to say, about standing, about Mohila. And the interesting sort of quirk here is that we're talking about the Solicitor General of Nebraska, of course, who's having to speak to a Missouri entity. And I assume that there are sort of behind the scenes reasons for who had been on the case the longest and was the most up to speed on the various arguments and so forth. And I think Solicitor General Campbell did a fine job, but I would just note that peculiarity. Ordinarily, you wouldn't have another state's Solicitor General defending a different state's program. So it was interesting to hear that. I think that the most direct version of standing that the Solicitor General said is look, 77% of Mohila's revenue comes from servicing direct loans. About half of all loans will be discharged under the Secretary of Education's program. That will cut Mohila's operating revenue from direct loans in half. Mohila gives $63 million, or has given something like $63 million to a state scholarship fund. If Mohila's revenue is cut in half, it's not going to be able to keep giving money at the same rate it's given before, sort of QED. Justice Jackson asked if there are offsetting fees and whether he needed to show that the offsetting fees weren't enough to make up for that. Campbell said it's hard to think that there'd be enough to make up for the loss of half of Mohila's revenue. Justice Kagan said that Mohila can sue and be sued, isn't here. SCOTUS usually doesn't allow standing in the shoes of another by third parties. But Campbell said the government is different, and he pointed to two federal cases, Sherry Cotton Mills and Erickson, where the federal government has been allowed to assert interests of federally created corporations. And he tried to say that the states are just asking for the same sort of latitude here that the federal government enjoyed in those cases. Campbell also said that Missouri has an interest in Mohila. It created it in order to provide financial aid. And so that if those payments aren't made, then the students in Missouri will be harmed by that. When pressed by Justice Barrett, he was also quick to say that, look, there's just a plain old argument that the state can speak directly for Mohila, that this is an instrumentality of sorts, and that's enough. I'll pause here to say that NCLA's amicus brief did focus on the standing question as well up front. But what we said is that we think that the states have standing under the Mohila theory that they're asserting, but we also think that the states employ people who benefit from the public service loan forgiveness program. That program is severely undercut by the Secretary of Education's waiver and modifications that went into creating this new program. This is the theory of standing that we are using on behalf of the Cato Institute in a separate case against the Biden administration's loan forgiveness program that we filed in the District of Kansas. But we think it applies to the states as well, because the states also have employees who are eligible for and benefit from the public service loan forgiveness program. That didn't come up at oral argument, but if for any reason the justices don't buy the Mohila argument that Solicitor General Campbell spelled out for them, I just want to reiterate that there is an additional theory of standing in front of the court from NCLA's amicus brief. Now, coming back away now from the standing argument, Justice Gorsuch, I think, was the first to get away from standing and ask Campbell to address whether the major questions doctrine applies and whether the Congress's appropriations clause authority is implicated. Campbell said there's even more reason for the major questions doctrine to apply because the Secretary of Education is invading a quintessential legislative function by writing off debt, and so that the separation of powers is deeply implicated in that action. Justice Sotomayor said no one's disputing that the Secretary has forbearance power. I would invite Justice Sotomayor to read NCLA's amicus brief. We are disputing that. Again, NCLA, but she said that the amount of money can't be the issue because forbearance is $5 billion a month already, and so the question is Congress's intent. Campbell replied that the HEROES Act doesn't give rewrite powers. Kagan jumped in to say, yes, it did. Says the Secretary can add terms and conditions to be applied. She says the statute's very clear. So again, this is just the statutory issue being joined on how far does waive or modify go? Does it allow you to go all the way to rewriting the statute in a way that essentially creates new programs with a sort of picking and choosing various words to assemble a new program out of, or maybe not words, but partial provisions. And then, as I said before, Campbell made the interesting point that the Secretary is not waiving provisions at all because they're still in effect for folks who want to use them. And he said that the in lieu of language has to be read in a sense of modification, not authorizing a wholesale rewrite. Kagan at this point puts forward a sort of an earthquake hypothetical and asked whether the Secretary could modify the program to include not just the borrower's loss of income, which the statute might cover, but say extend that to the primary earner in the borrower's household. And Campbell said that sounds like a new program. And Kagan resists that. She says the statute's very broad, but Campbell said that Congress preserved for itself the ability to discharge loans. Kagan asked where that is in the statute. Campbell said the CARES Act shows that Congress has a voice in an emergency. Presumably, he was pointing to the temporary suspension of payments that Congress clearly authorized in the CARES Act. And that's when Kagan said that we only worry about executive power when Congress hasn't authorized it. And Campbell then raises the Clinton v. City of New York problem. Once again, Chief Justice Roberts comes back to the major questions doctrine case, which I think tells you this is on his mind. This is now the third time Chief Justice Roberts has come back to ask about major questions doctrine cases and ask whether those other statutes would similarly had broad language in them that might literally cover the authority that was exercised by the government officials there. And Campbell agreed. He said, look, this fits very well within those cases. I talked earlier about Alabama realtors and that both of them are CARES Act extensions, sort of kinds of cases. Sotomayor said Alabama realtors was different because an eviction moratorium had never occurred before, but neither has this kind of massive loan forgiveness. So I'm not exactly sure what she was getting at there. She claims this couldn't come as a surprise because the Higher Education Act allows for loan forgiveness. But again, this wasn't done under the HEA. This was done under the HEROES Act. She claims that Campbell just wants to say that this rewrite is bigger than he would like, but that she said it's all semantics, that all of this is rewriting the statute. The question is just whether Congress allowed it or not. And she says that Congress did. Campbell sticks to his guns, and that waive or modify is just not broad enough to permit rewriting. He also points to grant overpayments as one named instance in the statute where the Secretary of Education could excuse returning funds to the government. And by naming one, Campbell says Congress implicitly excludes a wider scope for that particular form of relief. Justice Gorsuch then asked about the OLC opinion and its limits, saying that the program could only put people back in no worse position, not in a better position. And this program puts some borrowers in a much better position than the status quo ante. Of course, Campbell agreed with that. Actually, he said he disagreed with almost everything in the OLC opinion, but he agreed with that, which I thought was a funny line. Justice Kavanaugh said the argument on modify is good, but that waive is a very broad term. But Campbell reiterated that nothing's really being waived here. The program still exists, and that what they're really doing is creating new programs, and that this isn't in the Secretary of Education's wheelhouse because only Congress can create brand new loan discharge programs. So that this idea that this is out of the major questions doctrine sort of territory because we're dealing with student loans and the Secretary of Education is dealing with student loans. Campbell said, no. This is loan discharge, and that's Congress's job. And so it is out of the lane of the Secretary of Education. I thought he made a good point there. And that using the HEROES Act to forgive loans is unprecedented, which is another reason to think that the statutory text doesn't cover that, since no one's done it for the last 20 years. Justice Barrett then asked Campbell whether the loan repayment clause is okay. That goes to the scope of waive or modify, she says. And Campbell said that at some point an extension goes beyond a modification and the connection to the national emergency becomes too tenuous. Also, he noted that a pause maintains the status quo with regard to debt, but the cancellation puts people in a better position. He also said a pause keeps indebtedness from rising versus erasing that indebtedness. And finally, that when lockdowns were still going on, there was a pretty strong connection between the emergency and the forbearance on the loans. But however you look at it, this kind of wholesale rewriting of the law in the executive branch cannot possibly be okay. I would think even under the current lax standards for divesting legislative power under the non-delegation doctrine. But the court didn't talk about this in terms of non-delegation. It's gotten, some might say, sidetracked into its newest creation, the major questions doctrine, which, while useful in some sense, is getting us even further away from the text of the Constitution than the non-delegation doctrine did. So ideally, the court would return to first principles here and recognize that Congress cannot delegate wholesale rewriting of statutes to the Secretary of Education, even in an emergency. One might even protest that there's no such thing in American law as executive suspending of the law. That kind of royal prerogative is anathema to the Constitution. So to the extent the HEROES Act purports to delegate that power to the executive, we have a constitutional problem there as well. But that's not, those arguments weren't joined in the oral argument. And so I think if I were to hazard a guess about what's going to happen, I would say that the court is likely to find standing for the states. The court creates fewer problems by finding standing for the states given the state instrumentalities connection. than something that would allow any citizen to object. It's not a big leap at all from current law to say that Missouri has an interest in seeing that the $63 million in contributions from OHELA to the state scholarship fund do not dry up anytime soon. I think it's also likely that the major questions doctrine rides again here, especially with the Chief Justice bringing it up as many times as he did. The amount of money at issue here is ginormous. The chief is obviously bothered by the Secretary of Education acting when Congress couldn't. And this is heartland MQD territory for the chief. And I don't think there will be much explicating of the doctrine because this is so much like the previous cases. The major difference is that this statute is the Secretary of Education's to administer, but I don't think that's going to make a difference. And I don't think that that the doctrine will be said not to apply in the benefits context. I also don't think that the Solicitor General will get her wish to lose if she must, based on an arbitrary and capricious analysis. But the court may say something about borrowers not being in the same position as before, but in an appreciably better position. I don't think the court will reach the appropriations clause question. It doesn't have to in order to decide this case. And it's already granted cert on the CFPB case where the same question is lurking. So I think it, and if I had to predict, I'd say it probably takes a pass on that. I think it'll just say that waive or modify is not broad enough to cover what happened here, given the major questions doctrine dimensions of the case. And I suspect the Chief Justice might write the opinion and assign it to himself, but that's just sheer speculation. Let me just say a few words about the Department of Education v. Brown case. Once again, the court there spent an inordinate amount of time on the standing question and trying to figure out whether these plaintiffs have standing and why these plaintiffs are trying to knock down the Secretary of Education's program in order to hopefully benefit from some other program. They called it a bank shot and wondered whether or not that is the kind of action that plaintiffs can ask for. And I think the court is a little suspicious as well. At least Justice Sotomayor seemed to think that maybe these plaintiffs weren't really interested in having the HEROES Act program shut down in order for another program to blossom. Maybe they would just be happy to have the HEROES Act program shut down, full stop. And so do we really have plaintiffs here that are complaining about something in a way that they can get the kind of relief that they want? Is it very speculative to say that if the HEROES Act is shut down, that the administration would go forward with a new program? Now, one aspect of this I haven't talked about yet is the complaint that the Brown plaintiffs are making is, look, this was done under the HEROES Act. It shouldn't have been done under the HEROES Act, but the reason it was done under the HEROES Act was because they didn't have to go through notice and comment rulemaking, and maybe they wanted to do it more quickly or what have you. And that by holding up the stop sign here, the court would force the Secretary of Education to go back, maybe do it under the HEA or some other statutory authority where you would have to go through notice and comment rulemaking, and then these plaintiffs would be able to participate in the notice and comment rulemaking process. So they're essentially saying that their rights, their procedural rights have been violated because the secretary went through door number one when he was only allowed to go through door number two. It'll be interesting to see what the court makes of that standing argument. I believe this was the first argument at the Supreme Court for my friend Michael Connolly, and I thought did a very nice job for a first presentation at the Supreme Court. I'm not sure that the reason the court, I think, granted cert here was because the plaintiffs won below, and the Solicitor General in the United States wanted to defend the program in front of the Supreme Court. So I don't, I really think that most of the argument, most of the things that are going to be adjoined here by the Supreme Court, the various issues that they're going to really chew on, are going to be ones that came up in the argument in the Biden v. Nebraska sort of first argument. I don't know that there's going to be as much for the court to chew on in the second argument. I think that's mostly going to be a question of standing. And if they decide that the plaintiffs don't have standing, then that may be the only ruling that they make. They may not talk about any of the other substance because they'll already have the opportunity to do that in the context of the Biden v. Nebraska case. Now, if they do find that these plaintiffs have standing, and if they were to find that the plaintiffs don't have standing, that the state plaintiffs don't have standing in Biden v. Nebraska, and that the Brown plaintiffs do have standing in the second case, then the reverse would be true. Then I think a lot of the same issues would come up. But one of the things that has happened in the current sort of post-pandemic version of the Supreme Court is that after the normal time is allotted, the Chief Justice goes down and asks each justice if they have any more questions. One of the funny things that happened in argument here was that the chief started to cut off the attorney for Brown before he had done that piece of it. And then he stopped himself and then went down the line and asked if anybody had any further questions, and no one did. And the chief was kind of like, see? So I think that lack of questions really is what's leading me to say that there's not as much for the court to chew on there as there is in the Biden v. Nebraska case.
Thank you for listening to this episode of SCOTUScast. SCOTUScast is a project of the Federalist Society, a not-for-profit educational organization of conservative and libertarian law students, law professors, and lawyers, founded upon the principles that the state exists to preserve freedom, that the separation of governmental powers is central to our Constitution, and that it is emphatically the province and duty of the judiciary to say what the law is, not what it should be. Don't forget to subscribe to our podcast series, including SCOTUScast and Practice Group podcasts, on iTunes or Google Play. For an archive of past podcasts, as well as audio and video of past Federalist Society events, please visit our website at fedsoc.org/multimedia. That's fedsoc.org/multimedia.
This has been a FedSoc audio production.